Trent Bradshaw, Bradshaw Financial Planning, and thank you for joining us for Mind Your Money. Educational event again today. We're going to talk about wills and trust. Got a special guest with us, Jeremy Carter, a local attorney that we've worked with for a number of years. It's going to take some time today to cover some questions that Brandon and I are going to present. Also got Brandon Rogers, Certified Financial Planner, with us too. But to start off with, Jeremy, thank you for taking the time to join us. I know we've worked quite a bit over the years, and really appreciate it. You've helped a lot of our clients, bring a lot of knowledge to the table too, and guiding them through what can be uncertain times.
Thank you. Thanks for having me. I really enjoy getting to talk to folks and getting people to understand that estate planning is something that they need to do. And if they fail to do it, there's still a plan that's happening. It's just not the plan they may have intended. The attorney that I've worked with in the past, one of the older ones, always said that everybody has an estate plan. You either draw one up with your attorney and your financial advisor and it does what you want, or you're stuck with the default rules that come from the state of North Carolina or the federal government, depending on the type of assets you're holding. And many people don't understand that those default rules don't match their expectations. So we really do want folks to understand what's happening with their assets when they're gone or when they become incapacitated. And in that vein, there's several tools folks can use. The starting point, I think, for most people would be a will, just something that sets out what's going to happen to their assets when they die. And they get to pick the person who is the executor that's going to make sure that their process is carried forward, that their desires actually get executed after they pass away. For many people that are married, they name their spouse, their surviving spouse, as their first executor. A lot of folks will name children as alternate executors in case they both die in a close time to each other. And in that will, they say what's going to happen to their assets. The good thing about a will is it is a plan. You pick something. The bad thing about a will is it doesn't cover all of your assets. So both using state law and some federal law, certain types of assets pay directly to beneficiaries, not through your will. So I've seen wills come through where a person that's now dead has said, I leave the proceeds of my life insurance policy to my wife. But the actual life insurance policy itself, they had payable to someone else, maybe a child. And that child gets the money, not their spouse that they directed in the will, because the life insurance is its own separate contract, and that contract is more powerful than the will in that setting. And retirement benefits are similar. Sometimes that's governed under federal law because the retirement plan is still held at your employer. Sometimes it's a combination of federal and state law because you may have rolled a retirement account into an IRA out of a 401k or other federally governed process, and you've got a beneficiary named there. And what we like to explain to folks is you can control those other assets, those life insurance policies, those retirement accounts, by using a trust.
Can you touch on, you made a good point there. Brandon and I talk about the importance of beneficiaries and reviewing the beneficiaries, especially on the retirement accounts that we've got. Maybe it's a transfer on death or a TOD account. Like you had mentioned, life insurance, other accounts, maybe even an annuity or some type that's got a beneficiary name. That definitely supersedes what's in the will itself. But from a will standpoint, what amazes us, I think, is how many people actually don't even have one. Like you said, the state of North Carolina is going to give them one regardless of what they want to do. They actually have one behind the scenes, but having that will to direct other assets is very important. But reviewing those legal accounts like the IRAs and 401ks, et cetera, they take precedence over the will.
Yeah, normally if someone comes to our office for an appointment to review their estate plan, and especially if they do a revision or a new one, we try to get them to go talk to someone like y'all that's handling their financial assets, because if they don't go coordinate what they put in their will with their financial advisors, their will is only covering certain types of assets. And in North Carolina, it's over half of the people do not have wills in place. Many of those people may not need a will. If you don't own any assets, a will does not help you very much. If you rent your apartment and you leased your car and all you've got is some personal property, your will really may be fairly meaningless. But for those of us who own a house, own vehicles, have acquired property over the years, maybe we've inherited property from our parents and grandparents, that will is very important to make sure that what's been earned and given to you goes to that next generation the way you desire.
Yeah. And Jeremy, one kind of leads into a point that I wanted to make sure we cover too, is a lot of people have a lot of questions about what is probate. How do I avoid it? Is it important I avoid it completely? And, what does that mean? And I think it's kind of leading into what you were just kind of saying. Can you talk a little bit about that?
Yeah. And I had a family in the last week or so who had that same question. What is probate? What does that mean? Because they'd been to the courthouse before they came to my office. A relative had died, and so they'd heard the term probate. And all probate is the legal process in the courthouse where an estate is administered. If there is a will, that will is entered into the public record, and it's recognized as being that person's final will and testament that's going to direct their assets. If there is no will, an administrator ends up being appointed. Often it's a surviving spouse or child, and that person then is subject to following what the state law says the assets would require to pass through your assets to your heirs after the payment of your final bills. So the probate process guarantees to your heirs that there is a public record that your bills got paid and your assets got paid down to the beneficiaries named in your will or by statute, whichever the case may be. And a lot of folks are scared to death of probate because they've heard horror stories of going to the courthouse by some relative of theirs or friend of theirs, and they had to pay what they thought was tremendous amounts of money in probate fees and deal with the court system that's not user friendly. We encourage folks when they go through probate, whether they hire us or someone else, to hire an attorney. I tell folks what you tell the probate court, it's like talking to a police officer. What you say can and will be used against you later because it is a court system and you're a participant in the court system. And for a lot of folks, they wouldn't even go to the court system to do a traffic ticket without a lawyer, but they'll try to go do an estate administration because they don't want to pay an attorney to help handle that, and they believe they can handle it themselves. And normally it's much more expensive to fix it after they've started than it is to get it right from the beginning.
Well, that's a good point, Jeremy. We hear it all the time. People fear probate. They think they're going to lose half their estate value by going through the probate process, and that's just not true. And we'll see people, and I know we're going to touch on this in a little bit, that'll set up trust just for this purpose, and they don't necessarily need to do that because they're thinking they're going to lose all their assets, and they go through all this expense to set that up, and it may not be the right thing. So fear drives a lot of decisions that are not correct, and that's why working with an attorney like yourself is so important.
I think it's important, and again, it doesn't matter to me if you pick me or someone else. Just get someone who's helpful to get that done. But the good thing about probate from a estate administration process is twofold. One is it makes sure that all the final bills of a person did come to the fore and get paid, so that nobody gets surprised down the road with a bill that was unexpected. Because there's a process that the court has, that an ad runs in the paper and creditors are getting notified. And if they don't make their claim in a certain period of time, their claim can be barred by the executor as being untimely. So that gives protection to the heirs from bills coming in later.
That you just made another good point. You need to have some assets roll through the probate process to some extent, just in case, to cover any outstanding expenses. Because if we do our job as planners and avoid probate for everything, someone may get a direct bill to pay that bill out of their own assets. Is that correct?
Or assets they think they've already inherited.
Okay, yes.
because assets in North Carolina are recoverable to the extent creditors did not get paid in certain settings. So there's exemptions. Life insurance payable to somebody, they can't pull that back in. But if somebody set up one of those trusts you've talked about, and their sole purpose of the trust is because they don't want anything to go through probate, those trust assets are often recoverable, at least to the extent creditors are needing to be paid. So the creditor can have an executor or administrator appointed in probate, even though you didn't go there, and that administrator can seek to pull back in enough assets to pay the bills. So those trusts that are designed just to avoid probate with no other purpose are often a little bit faulty in thought. You do keep privacy. You may reduce the probate court's fee because their fee is based on the value of the assets that go through probate. But even that fee is not, I'm not going to say it's not substantial because it can be substantial, but North Carolina has a cap on probate fees of $6,000. To get to that cap, you would have to have probate assets of over $1.5 million, because it's $4 per thousand. So for $1 million estate, you're paying a $4,000 probate fee. And when you think about percentages that we pay to the government, 0.4% may be the lowest rate you'll ever pay the government for something to happen. And it is a tax. It's going to the state of North Carolina. But that probate fee is only going to factor in liquid and tangible assets and stocks and bonds that go through the probate estate. So it doesn't count real estate that may be passing by the will to your heirs. It doesn't count the life insurance going to someone. It doesn't count payable on death accounts like Trent mentioned, TODs or PODs. It's only counting those assets that go through the terms of the will to your heirs that are not otherwise excluded. So it's something we can manage to control the cost, but it does need to happen. And for real estate purposes, for folks who own real estate, it's a necessary component to make the title good so that the heirs can sell the property, even if it passed to them by trust. If a trust passes title to an heir, that person, without a probate process being done, could not sell that property for about 2 years without having issues about the creditors of the decedent, because the probate process makes that public, that those bills got paid, and that acquiring person buying that real estate can get good title, knowing there's nobody who's going to have a claim against this land to pull it back into an estate. So it has a process.
One of the things, Jeremy, is you're still talking about the trust from that end, and obviously we know, as you just mentioned, it could be something that could help you avoid it or limit the probate process itself. But what are some of the other reasons? Again, we get people need a trust, because we get that question a lot as well. If some people, may hear from other areas, other people in the community saying, "Hey, well, everybody needs a trust." But I mean, what are some reasons, I guess, that you see people needing trust for outside of the probate process you'd mentioned and the privacy deal?
Yeah, I will tell you that I do not believe everybody needs a trust. I believe some people need a trust. So the main reasons I think trusts are beneficial, first is you got to figure out your own circumstances. And am I a person, or is my surviving spouse that may be left behind a person who knows how to manage my own financial affairs? Or may I become someone who's diminished in capacity and needs help managing my affairs? Now, power of attorney can be helpful in that. You can name somebody your agent, and they can help manage your affairs if you lose capacity. But if you put your assets into a trust while you're still living, and they call that a revocable trust or a living trust, you put those assets over there, and there's a trustee that's usually yourself, with the limitation that if you lose capacity, someone else takes your place. So you have a management position already appointed. It's sort of like a corporation that puts a vice president in place to back up the president in case the president becomes incapacitated. The vice president still keeps the company running. And that's how a trust works. You have a successor trustee who, if you lose capacity, is going to step in, and their job while you're living, usually in that trust document, is to make sure all your bills get paid and your assets get managed, And if you have a spouse, that they're cared for and that your children are cared for. So it's operating while you're still alive. And so a lot of folks, this is helpful, particularly if they start getting older and realize that they're having a harder time keeping up with their finances. I've had clients who have, as they've approached their 80s, for instance, have realized this is just something I don't want to do anymore. They may be perfectly able to do it. They just don't want to deal with that anymore. And they say, okay, Joe is my successor trustee. I'm going to go ahead and resign as the main trustee and let him take over. That way their bills are getting paid. Their accounts, especially if they're having stocks and bonds and investment accounts that need to be monitored, somebody is monitoring those. And I know Trent has heard this because we've been in the meetings with folks who come in and say, I don't want another thing in the mail from a stock company telling me about all the stocks I own. They get those annual statements from their stock companies, the prospectus for a mutual fund. Those have to be updated by federal law at least annually. And if you've got substantial assets, you may be getting 50 of those packages a year saying what you own in your stock account. And if you've got a trustee who's now in charge, that trustee gets that mail and has to wade through that process. They deal with your financial advisor and they make sure that your plans are met up with. And that's better than losing capacity and having a guardian have to take over the process. So that's number one, is it's for your own well-being. If you anticipate you may lose capacity or that your spouse may not be gifted in managing your finances. The other is, in my mind, that you've got a need that's going to exist beyond your own life. So if you have children who you know by their own actions so far in life cannot handle owning assets. If they're going to inherit money from you and they already have credit card debt, they've already declared bankruptcy twice, they've been sued for not paying their car payments and had their car repossessed. If those are what your heirs look like, a trust is a tool that can be used so that they can become able to benefit from your assets and your hard work without losing your assets to their creditors. So they end up getting a check every month or every quarter from your trustee to help meet their needs, but their creditors can't come take those assets to pay debts that existed before they owned them. And you can be very tailored in what you let be paid for. You can say it can only be used to pay health care. It can only be used to pay education. But it can be very broad that all the income goes to my heirs and the principal sits tight until there's a bigger need. And you may let that principal skip another generation to your grandkids or whoever you want it to go to. And you can even make it so that your child or children has the power in their own will to say who gets that money when they die. They call that a power of appointment. And that's something that we can put in a trust so that you can control property beyond your own lifetime and through the lifetime of your next set of heirs and make sure it gets to where you want it to go in a way that won't be wasted. So we see a lot of folks thinking about trust in that setting. And if you've got minor children, that's a different reason, but a very substantial one. Those trusts may not last as long. They may be designed to last until your children reach a set age, 21, 25, something like that, where they might be more mature. But if you have children that are under 18, if they become beneficiaries of your estate, they will become the owners. It'll just be through a court guardianship process. And the court typically would require that guardian to post a bond and to go through the court to use those assets. And effectively, those assets will not be available to your child until they become 18, unless there is a substantial need that cannot be met by a surviving parent. But all those transactions get governed by the court rules, usually requiring a court order for most expenditures. That can be costly.
Yeah, that's a lot of good points. I'm glad you covered that, and that's some of the big questions we get all the time. So thanks for that insight on the trust side of the equation.
Yeah.
Can we let's kind of jump to some important documents as far as the estate planning documents. I know obviously we've talked about wills, we talked about potential need for trust. Talk about the difference between the difference of durable power of attorneys, healthcare power of attorney, living wills, things of that nature, and some things you should have in place there.
Sure. So if you don't have a power of attorney and you lose capacity, there is no one automatically in place to be able to sign your name for you. So if you lose capacity and you can't sign your checks, someone in your family or Department of Social Services is going to have to go to court and have a guardian appointed to make those business decisions. They'd also have to make your health care decisions. And so there's a guardianship statute that covers that. But again, it is a court process, and that can take time, and that is expensive. That is I'm going to call it an adversarial process. So your heirs are actually having to sue you to say that you lack capacity, and a court-appointed attorney gets put in there to help you as the person who's lost capacity. And you go to a court hearing where everybody is sworn in and testifies about what's going on. And a judge either has to appoint a guardian or say, no, they still have capacity, which has caused major issues in a family by that point. If you name a power of attorney and you lose capacity, that person can act as your agent. But that, you mentioned the word durable, and that is the key, that the power of attorney document itself has to say that this power of attorney is effective even if I lose capacity. If you've already got a will or revocable trust in place, we can give the agent the powers, even if you lose capacity, to continue honoring that estate plan, to make gifts that may need to be made to match your estate plan, to put assets into your revocable trust, so that when you pass away, your agent has continued to make things happen the way you desire. That's for the financial side. On the healthcare side, North Carolina has a healthcare power of attorney document where someone makes your healthcare decisions for you. The other document that's out there that is still a viable document is called a living will. People often use those terms interchangeably, but they're actually two different documents. We tend to recommend folks to use a healthcare power of attorney. And by North Carolina's rules, and I would argue by the Constitution, as long as you're able to meaningfully express your own healthcare desires, the physicians are supposed to listen to what you want as the person who's now ill. But with a healthcare power of attorney, you will put in place a document that says if my physician determines I lose capacity, and that could be a temporary event from a concussion or being under anesthesia from surgery, or it could be permanent from having Alzheimer's disease or something else that doesn't go away. Once the physician determines you lose capacity, then you can nominate who it is that will make your healthcare decisions, and the physicians are bound to follow that decision. The other thing that you can give to that agent is the authority to dispose of your remains. If you're an organ donor, that person has the authority to make those organ donations. The healthcare agent is also the person who signs to have your funeral handled, be that by cremation or burial. That healthcare agent, you can give them that authority. So they've got that ability just immediately after you die to handle those affairs that need to be handled in a timely fashion.
That brings up a good point, Jeremy. There is a lot of stress on an individual that's given a healthcare power of attorney and has to make those hard decisions. Is there a document that people can put in place that would help alleviate that and let the person make their own decision, but yet have that document available to be able to, do not resuscitate type provisions, any type of healthcare proxy to help your healthcare power of attorney with the, I guess, lingering decision that has to be made at the end of life?
You're talking about the actual them feeling bad or guilty about having to make decisions that maybe cause someone to, in their mind, pass away.
Correct. Because if you have to determine, the doctors tell you that there's, potentially not much hope here, you need to make a decision which way you want to go as far as life support or whatever. There's documents you can put in place to take that stress off your power of attorney.
Right.
And the other family members as a whole, because it's not sisters and brothers, one person making that decision. It's the parent actually making that decision.
Yeah, so there's a couple of things that can be done. One is if you're dealing with somebody who is in a progressive terminal illness situation. So if as a, for instance, I have some kind of a cancer diagnosis that they know couldn't be cured, I can meet with my physician and go through a form. It's often called a MOST form, where my physician will actually go through that with me, and there will be a medical order that matches my desires. And it's usually helpful for the healthcare agent to be there at that meeting with the physician and the principal before the principal, the person who's having the medical procedure, is done, before they fully lost capacity. So they're able to have input with their agent there, with the physician there. So the agent's got the document that makes them the healthcare agent. And then the doctor also may be putting together a medical order that says, here's what we've all decided. This was a team approach. So when those final days do arrive, those decisions have already been determined. If someone comes in and they dial 911 because they found you fallen, the ambulance is going to arrive with the paramedics. They're going to see that form that's a medical order that says do not resuscitate. That's not something I can prepare as an attorney. That does require a doctor's order for those paramedics to be able to follow it. But again, that's usually done in conjunction once the healthcare agent is appointed with the healthcare power of attorney and a meeting with the physician for someone who is then probably heading down a progressively terminal state. So that way the agent knows what you want. The hard part that we get is most of the folks that are agents don't know they've been named the healthcare agent until the need arises. So mom or dad, aunt, uncle, whoever it is, has made documents with their attorney that named healthcare agents. They don't share with the agent that it's them. And then suddenly they get a call that mom or dad is in the hospital. Other family members have gone through the important papers and found this healthcare power of attorney, and you're it. And so then you've got to make those decisions without really knowing and having had that meaningful discussion with the person. So all you're limited to is what's on the paper, because we do get a lot of folks that they don't want their children to know that they've been named. Right. They don't want to cause dissension amongst their children. Say they've got 3 children. Everybody knows which one is going to be the decision maker, but they don't want their children to talk about it yet. They're not comfortable with the process of dying or becoming incapacitated. And so it becomes a surprise. Let's go search mom and dad's house, hope we find a paper, and then we'll figure it out. And that's a bad way to learn.
Right. Yeah. Yeah. And I think that's a good point. And that's something that we always try to talk about is it's a difficult conversation to have, period. Not many, people want to have it, but it's something that we really need to plan for and put in place because we know it's going to happen eventually. And communication is a big deal. Communicate with your family members. Let people know you got a plan in place. People know where these important documents are. But as Jeremy mentioned before, there's a lot of people that don't have this in place. There is a plan out there for you, and the state of North Carolina has it out there. So, but make it your decision on what you want and what to have in place. So that is definitely a big deal. Communication is huge. But again, we covered a lot of stuff today, and we could talk all day about this. And I know this is a really big hot topic with the individuals that we meet with. But wanted to thank you, Jeremy, for doing this. If anybody has any additional questions for us, just, get in touch with us, myself or Trent in the office here. We can coordinate any type of meetings or answer any questions. And again, utilize that time with Jeremy and his folks there as well to, take a look at these things. He'd be happy to take a look at what you got going on, give you some recommendations from that end. But again, Jeremy, thank you for taking some time to do this. Again, very important topic that everyone needs to take a look at. But, thanks for joining us today. And again, reach out with any questions.
You're welcome. Y'all have a great day.
There goes a shirt right off my